Good afternoon. Welcome to the Appellate Division First Department. As I call the calendar today, please ask for the time that you actually need. And remember that if the panel has additional questions past the time you've been allotted, we'll ask them, and you'll have an opportunity to answer. We have read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise, let me know who you represent and how much time you are requesting. People v. Julio Cuevas. Submitted. People of the State of New York v. Leasing Expenses. How much time do you both want? Don't you want time for rebuttal, counsel, on your appeal? All right, I'm going to give you both 5 and 1, 5 and 1. And how much time would you like? 6 and 6. 5 and 1, 5 and 1, and 6. Lewis v. TCPR and C LLC. 3 and 2 and 4. Encarnacion v. St. Barnabas Hospital. 4 and, do you want time for rebuttal? 10 and 4, I'm sorry, I missed that, okay. 5 and 2 and 5. People v. Hernandez. 4 and 1 and 4. Suazo v. Charles Schwab and Company. Okay, you saw that Mr. Suazo wrote to us and said he's not coming in. Okay, we'll let you address the court for 2 minutes. K. v. Banchik. Do you have an opponent with you today? Oh, okay. How much time do you want, counsel? Five and 2 and 5. Now, on RC and Infant, my understanding is that one of the parties is stuck in the subway. Is that right, counsel?
No, I'm here.
Oh, you are here. Okay, very well. How much time do you want?
7.
Just 3? All right. 5 and 2 and 4. CMB Export v. Motcomb Estates.
Appellate 6 and 2, Your Honor.
Granted. Five and 2 and 5. Hofstra University and St. John's, of course, versus United Educators. We've got 2 appellants. Counsel, are you here for both universities? Okay. All right. So we'll go with 5 and 2 and 5 and 2. I am recused on Katskevich, but how much time do we want? Do you have a cross appeal, counsel? No. Okay. Give you 4 and 1 and 4. People v. Tyler Hibbert. People v. Hibbert. Submitted. Doom v. City of New York. 4 and 1 and 4. Lee v. Lyft Incorporated is on submission. First case up is People v. State of New York, People of State of New York v. Leasing Expenses Co. Please.
Thank you, Your Honor. Hillel Parnas Law Firm for, as we said, most of the, today we had submitted some supplemental authority. I brought copies with me to hand up.
As you like, counsel, you can just also give us the citation.
Okay, the supplemental authorities are Agapur v. Northern Leasing Systems, 763 F sub 3rd 580, and Agapur v. Northern Leasing Systems, 2026 Westlaw 1183399 at the Second Circuit.
Why don't you proceed with your argument?
Thank you, Your Honor. With respect to the supplemental authority, we have a cover letter that explains that. This was the first, I believe, the only case to go on the same issues that are here, but the first civil case to actually go where merchants were saying that they had been defrauded. The jury returned a verdict for the merchants, but the Southern District of New York reversed that, said that the plaintiffs were unable on the facts to prove forgery, unable.
Counsel, why are we revisiting, this is of course a question raised by the other side, why are we revisiting the March 2021 order? That's final, is it not?
Well,
no, you
so
think not, but explain to me why I'm wrong about that.
Sure, Your Honor. And again, just to clarify, because I'm sure I wasn't clear about that, the supplemental authority came in after the fact. But
we found in a prior appeal of this case that it was supported by, quote, a mountain of evidence. I've never seen that in one of our decisions before. So why are we revisiting this?
because as we read what's at record 196, when it went up to the Court of Appeals, the Court of Appeals was saying that the first time we came through was premature, that it had to go back down to become final, and that's why we're here again.
Counsel, that's just a reflection of that the Court of Appeals jurisdiction only comes from final decisions of this court, and there were still questions about the accounting and the amount of money that your clients would have to disgorge. So I don't find that argument particularly compelling, but please continue.
Understood, Your Honor. Again, that's our argument about why we're able to revisit, why we should revisit those issues. They are laid out in great detail in my brief and in my co-counsel's brief. Again, it's particularly troubling that the Attorney General was able to drive through the second case against different people, finding that individuals not named in the first case were alter egos of individuals and companies named in the first case. And we laid it out in our briefs, and again, I would submit that if you look at the opening brief starting on page 23, all of the reasons why this should have gotten more attention down below and why it's become highly prejudicial to the individuals, especially, they're at issue here. There is also an oral argument issue, which is new, which I believe my co-counsel is going to be addressing.
On the oral argument issue, I mean, you have to agree that the uniform rules provide that the trial judge has absolute discretion to decide whether or not there's oral argument. And I can understand, I would be aggrieved as well if I was told I'd have oral argument and then I say I've got a religious observance I have to do, and then the court said no. But doesn't the court have that power to do that?
I believe we both said that the court has that power, but under the circumstances, the way it was exercised was highly improper. Again, the court said there will be oral argument, set the date, and it was a month off. And as soon as my co-counsel told the court that date doesn't work because of religious observance, the court immediately said there won't be oral argument. There seemed to us to be no logical reason why, if it was a month off, if there was no rush on the court's part, that it couldn't be rescheduled.
Counsel, did you request oral arguments in your papers?
I believe we did. I believe we did. I'll let my co-counsel address that, but I believe we did. But again, it was because the court had said it would happen, which is something we very much wanted, only to pull it back because of apparently a scheduling issue, but it being a full month off, it didn't make logical sense to us. We're stopping short of accusing anyone of what we could accuse them of, but again, under the circumstances, it was highly prejudicial to us, to our clients, and we would have wanted to have that oral argument.
When was that motion sequence, when did that motion sequence start?
That motion sequence started, that was after we had been here the first time. I don't have the exact dates in front of me. I think I can pull it up. I believe I laid it all out in my brief. Just if you give me one moment, please.
If I recall correctly, it started many, many months before, so there was no particular rush.
Yes, we agree with that. There was no particular rush, and we were pleased that the court had said we would get the oral argument.
Thank you, counsel. You have time to rebuttal.
I'll
Thank you.
find the answer.
Thank you, thank you.
Please the court. My name is Saul Fader, Regis and Edward Stone and Fader. I represent two of the appellants, Leonard Mezzi and Fieldstone. I'd like to address only two of the issues regarding Leonard Mezzi, which I believe would show to this panel that there was substantial prejudice against Leonard Mezzi and justifies severing him from the other respondents and not holding him liable. There was a finding of almost $3 million joint and several against all of the respondents, including Leonard Mezzi. And as the record shows, the Attorney General and the court below relied heavily on the prior Northern Leasing case, which Leonard Mezzi was not a party to. He was not given an entitlement, therefore, to cross-examine anybody, to put in any evidence, to file papers. He was not a party to that case. And he was not a party to that case, not by accident, as the papers submitted to the court show. The AG knew he was an investor in Northern Leasing. The documents that are submitted to this court show that the AG made an educated decision not to include Leonard Mezzi in the Northern Leasing case. Therefore, he was not given any opportunity to defend any of the issues raised there. Comes to this second, the leasing case, which is now before you, he is now included. He's included based upon the allegations that were found to be a problem in the Northern Leasing case. The court below found, and if I may,
Did he participate? I mean, is there any evidence in the record that your client participated at all in the transfer of the assets of Northern Leasing to these two new companies?
No evidence in the record whatsoever. Not only no evidence, not even an allegation that occurred. So we believe that since the court below,
I mean, it did happen, the transfer of assets from Northern Leasing, right? You're just saying your client was not involved with it.
I'm saying not only my client was not involved, I'm saying my client doesn't know whether or not what the court just said is accurate or not accurate. We don't know that that's true. No evidence was produced as I saw it in this leasing.
That mountain of evidence that I referred to earlier, you don't agree with that?
No, I don't. I don't agree with it because
We already found that, though. How can this panel, how can this group of 5 judges change what we already found?
so I can't ask you to do that, but I can ask you to sever Leonard Mezzi from the other respondents because there was no mountain of evidence against Leonard Mezzi. There was no allegation that Leonard Mezzi himself did anything whatsoever with regard to transfer of assets or defrauding any of the alleged lessors. None whatsoever. If I may now turn to the second issue that I think entitles Leonard Mezzi some relief, and that's the oral arguments. I must correct counsel, there was no request on the motion papers that was submitted for oral arguments.
Thank you, counsel.
There was no such request, but
So when you submitted, since there was no request, the understanding is when you submitted your motion papers, all of your arguments that you were relying on was contained therein.
no, well, that wasn't our intention, but we certainly did not request it as we could have.
But it was submitted to the motion submission court.
Yes, it was. Yes, it was. And then, much to our great relief and joy, the motion court elected, as it's entitled to make the decision to hold oral arguments.
Counsel, what would be the effect of you bringing up arguments at oral argument that weren't contained in your motion papers? What would be the effect of that?
I would have emphasized, as I just emphasized now to you, that Leonard Mezzi should have been severed and separated from the other respondents because there was no allegation whatsoever in the papers submitted to the court that he himself did anything wrong.
I guess the import of that question, though, is that that would have had to have been suggested and argued in your motion papers. You couldn't bring it up for the first time in oral arguments, right?
That is correct. However, as your honors know, oral arguments have an effect. And when you voice something and have it heard by ears that are listening,
But your adversary wouldn't have been on notice that you were making it. What would be the effect of them not being able to respond or to an argument that's not made on notice?
it was made on notice. It was contained in our moving papers, but our oral argument emphasizes those points, highlights them, and has an effect on the people that listen to the oral arguments. And that we would have had that opportunity. And the court below gave us that opportunity.
So then if you would have then said, you would have then had the full opportunity to be heard on your papers.
I would have had the opportunity to let the court know why I thought the arguments we made in our papers were serious and should be given a lot of credence.
Thank you, counsel. You have time to rebuttal.
Thank you.
Good afternoon, and may it please the court. Blair Greenwald on behalf of the state.
Can we start with Ms. A?
Of course, Your Honor. It would be completely inappropriate to sever him for several reasons. One, which is purely procedural, is that he did not move for severance or ask for severance below. But more,
Counsel, bring the microphone a little closer, if you would. Thank you.
but also, when the court found him liable and subject to the restitution order in the previous appeal, that was based on direct evidence, including his own admissions in his deposition. That is at, excuse me. That is at page 174 of the record in the previous appeal. I will also note that what the record there shows is that he was the money guy. So he was the principal investor, not only in Northern Leasing Systems in the previous appeal, but the principal investor in setting up leasing expenses and NLSEF in this proceeding, and using the same trust structure in order to basically insulate himself. The record here also shows that he funneled the fraud proceeds from the lease collections to one of his companies, that is Fieldston, and that the record in the previous appeal at pages, 262 to 267 shows a business record search of Fieldston Capital. The only two potential employees that the business search found was Mizai as the manager and his daughter as the only agent. So not only is he setting up the companies, he's also diverting funds to the company that he solely manages. And that is why this court found him liable. That is why he was subject to the restitution order in the previous appeal. And that is why he was properly on the hook for the restitution here. I will also just briefly note that, as has been mentioned, this appeal is really limited to the restitution calculation. Neither in the papers nor here at oral argument have I heard any attacks on that calculation. It is also perfectly consistent with the same restitution procedure used in the Northern Leasing case that this court affirmed.
Was it a due process violation not to have oral argument?
No, and in fact, I take appellants here to concede that not only do they not have a right to oral argument, but it also is not a due process violation, because all that due process requires is notice and an opportunity to be heard, and their papers provided ample time and opportunity to be heard in argument and in evidence. They submitted evidence of only one deduction. The court gave them that. The Attorney General agreed to that deduction, and they have not here or below shown that they suffered any prejudice, nor could they, because they were again, given ample opportunity to provide their arguments there, and could not have, untimely raised arguments that were not preserved in any form of argument. If the court has no further questions, we would urge the court to affirm the restitution calculation.
Thank you, counsel.
Thank you.
If I do nothing else in my minute, I want to apologize to Justice Rosado for, I should have taken my own advice and said, I don't know.
Apology needed.
And I appreciate my co-counsel correcting me. To Justice Friedman, starting on page 17 of my brief, my opening brief, is where we detail the sequence of events that led to the oral argument not happening. And it was April 26, 2024. when petitioner respondent moved for the entry of money judgment. So
So this motion is coming on for oral argument more than a year later.
correct. I'm sorry. Well, they moved on April 26, 2024, and we were told that argument would be October 17, 2024. We were told that in September, so I'm not sure if I misunderstood you.
No, there wasn't any particular rush to, that would have precluded an adjournment.
That's the point that we're trying to make, Your Honor. And to that same point, again, going back to something that we've been beating the drum about from the very beginning, was especially when it comes to my clients, JS Ventures, Mr. Schachter, and Ms. Krieger, who were new to the second case, completely new to the second case, as well as my co-counsel's clients, Fieldston and Mezzi. We were never given an opportunity, despite wanting to put in proofs, despite the AG not having any opposition to us putting in proofs, we were given no opportunity to demonstrate to the court that JS Ventures and Fieldston, against whom there were no fraud claims whatsoever in the petition, there were no fraud claims against them, there was no evidence that the money had come from any illegal or improper place.
Thank you,
got
counsel.
to them.
We've given you
and
a
would have-
fair amount of extra time already. Thank you.
Thank you, Your Honor.
If I may, Your Honor, AG's office just asserted that Mr. Mezzi should be liable because there was a trust that he was involved in. That is an incorrect, untrue statement. There was a trust. The trust is owned by his children, not by Mr. Mezzi. His children are adults with their own children. Some don't even live in this country. They have their own financial issues. So to say that because the AG found that there was a trust and added the trust and the individual trustees to the case doesn't make Mr. Mezzi personally responsible for the actions of that trust.
Well, I just understood their argument to be that it's not evidence of anything in particular, except insofar as it shows some desire to insulate the parties who are in the trust and are beneficiaries of the trust from the fraud. That's all I understood it to say. It's not like per se it's some kind of violation.
If the children create a trust, not Mr. Mezzi, and the children put money into the trust and make investments with that trust, that's not a showing that Mr. Mezzi did anything.
Counsel, there's a long history here. You know, and you describe your client, I think, in your brief as a innocent elderly man.
Yes.
I'm not sure that the facts bear that out. Thank you. Lewis v. TCPRNC LLC. Please.
May it please the court. Nicholas Bruno from Horn Appellate Group for the plaintiff.
Counsel, it's, I think, undisputed that there hadn't been proper letters of administration issued at the time the court made this issue. So is your real argument here today that when the court made its determination, it made it with prejudice as opposed to without prejudice?
Correct. Yep. So under the plain terms of 205A, we're essentially requesting on this appeal that we have the ability to file a third action, which we argue is entirely consistent with the plain terms of 205A, as well as this court's precedent and the Second Department's most recent precedent in Tumanina and its progeny. And if I can just highlight a few of the cases from this court that we cited in our brief, specifically Zach.
Yeah, counsel, you do cite that in your brief. Zach's not quite the same, though, right?
That's
I think
correct.
Tumanina is the stronger precedent for you. But tell me, has the plaintiff obtained letters of administration yet?
At this moment, I am unsure. But
You're not sure?
I am not sure if they've retained
Okay,
it.
well, the reason I ask is that there's this policy argument that lurks in this case that should we put some kind of due diligence gloss on 205A? Because otherwise, people will just keep not getting letters of administration and keep refiling and refiling and thereby evading the statute of limitations. So when's he going to get the letters of administration? And should we be worried about parties that don't do that?
I have two responses to that argument. First, that is, putting that gloss on it would be contrary, in addition to what is the express terms of 205A. So that would go beyond what was actually in the statute. And second, that question was addressed explicitly by the Court of Appeals in Malay, where they said that the threat of, or the concern rather, of plaintiffs' counsel filing frivolous notices of appeals to draw out the litigation it is a concern, but is overblown and not one that is consistent with the statute. No
Please.
further questions? Okay.
Continue.
I would also like to highlight, if the court is persuaded by Tumanina, the Second Department's one of their most recent holdings in a state of Moore, which came out earlier this year, the defendant brought up a similar due diligence argument in the briefing, and the court rejected that, saying that it was outside the terms of the statute.
Thank you.
May it please the court, Teresa Scotto-Lavino, Louis Joes, Avalona Villas for the respondent. Just very quickly, I'd like to set on something mentioned in the reply brief. The appellant said that we had waived our public health law claims and our negligence claims in the reply because we didn't discuss it in the respondent's brief, but this was not something that was ever presented to the court in the appellant's brief. There was one question presented, was concerning the with prejudice dismissal of the wrongful death action only. As far as the cases submitted, as appellant discussed, Zach is one of them. Not one of the First Department cases concerns a third filing.
Well, what do you do with Tumanina?
That is a Second Department case. It talks about a third filing, but it was a third filing with a limitation that within that 6-month period, that grace period given by 205, that they would obtain letters of administration. At this time, I don't even have any record that the appellants filed any type of petition to the surrogates court for letters in this case.
This limitation, counsel, that you just referenced, that wasn't in the appellate division decision, was it?
I'm sorry?
The limitation that was given in terms of getting the letters of administration, was that in the appellate division decision?
I believe it was the lower court.
Okay.
Upheld in that decision, but mentioned in the lower court decision was that the third filing would be permitted if the letters were obtained within that successive 6-month period. So I don't believe that this has anything to do with this case.
But those facts are similar to what we have here, where we're talking about getting letters of administration, right?
They aren't similar in the sense that, yes, they're similar that he's getting letters of administration, but they're not similar in the sense that in Tumanina, they prove that a petition had been filed, and basically the receipt of letters of administration was through no fault of the appellant in that case. It was a delay in the surrogates court. And we understand that there are delays, but that's not the case here.
Well, we don't know what the case is here, right? Is there anything in the record about the delay in getting letters in this case?
No, there is nothing. And 205 talks about that type of diligence when it talks about a dismissal on a lack of due diligence for failure to prosecute. It talks about the diligence here. Appellant mentioned Malay. That also talks about the diligent plaintiff. In this case, there's no proof that we have a diligent plaintiff because appellant counsel, counsel in the regular court, nobody's proved that they even filed a petition.
205A requires a determination of diligence in order to obtain the savings provision?
Only when the dismissal is on a failure to prosecute.
But we don't have that here,
We
right?
don't have that here. But
So then that wouldn't apply to the facts here. Reading in a diligence standard wouldn't apply to the facts here.
I believe that it is in the sense that appellant is asking you to apply to Mania, and he's discussed Malay, and those cases, Malay is a First Department case, and it talks about the diligent plaintiff. So there is maybe not an actual standard here, but there has to be some form of proof that there is some follow-up, there's some diligence, that this is not the fault of the plaintiff.
Thank you, counsel.
Thank you.
I'd first like to just discuss the waiver argument.
So is it your position that you can just serially keep on restarting these actions, started, get dismissed, started, and keep on relying on 205A?
Our position is that 205A doesn't have a diligence requirement within the terms of the statute, and also the economics of litigation would deter plaintiffs from continually filing notices of appeal and drawing.
So in your view, you could do it 5 times, you could do it 10 times?
Yes, Your Honor, and that's consistent with all of the precedent from this court, Second Department, and the Court of Appeals. And I would just like to highlight page.
But then, what do courts do then to stop that, right? Because then at some point, there's a public policy argument to be made that that shouldn't be allowed to continue.
That would be a question for the legislature. And also, as discussed in Malay, that would be entirely constrained by the economics of litigation. Continuing to extend the litigation with no hope of a payout for the plaintiff's bar would just economically dissuade plaintiffs from just continuing to draw it out.
Your adversary just argued that in Tamenia, that there was a level of diligence on the part of that plaintiff, whereas there's no level of diligence shown here. We just don't know what's happening. Why shouldn't we adopt that position, that case is not factually similar to the facts here?
Even if this court were to distinguish Tumanina, this court would still be constrained by the express terms of 205A. I'm not certain of the circumstances that allowed evidence of the diligence to appear within the record of Tumanina, but that was never a question at the motion court level for us to have an opportunity to present that evidence. And we didn't present that evidence because we don't need to under 205A.
Thank you, counsel. Thank you both. Encarnacion, the St. Barnabas Hospital. Please.
Good afternoon. May it please the court. I'm Samantha Quinn, counsel for defendant appellant St. Barnabas Hospital. Defendant submits.
Counsel, stay close to the microphone. I'm sorry, maybe I have hay fever or something. I'm not hearing well today.
Defendant submits that the court below erred in denying our motion to set aside the verdict based on numerous prejudicial errors that occurred during trial.
Can you focus on the missing witness charge to start?
Yes, I can, Your Honor. So the crux of the missing witness argument is that Dr. Galena, the surgeon in this case, the one whose care is required to establish the connection between the accident and the injury, the one who the plaintiff's counsel opened by saying had the gold standard view of this herniation, which was also reiterated by his expert, he did not testify at trial. And this effectively denied the defense the opportunity to question him about the justification for his decision to proceed to surgery, about also his interest in the case. This is
Dr. Galena's voice did come in at trial, though, right? Because Dr. Guy testified about something that he had written in the charts. Am I mistaken about that?
No, essentially what the plaintiff did here was plaintiff called Dr. Guy, who was retained 5 months before trial, and he replaced all of the treating providers. Dr. Guy's purpose here was to synthesize the medical treatment and deliver it so that the actual treating providers weren't subject to
Also,
cross-examination.
he's Guy is a physiatrist.
Yes.
And Galena is an orthopedic surgeon.
Yes, he was a spine surgeon. So Dr. Guy testified as to radiology, he testified as to neurosurgery, he testified as to physical therapy, all of these things.
Did the plaintiff make any showing that Dr. Galena was not available?
No, there was no such showing, no such claim. In fact, the defense counsel for St. Barnabas Hospital notified, we weren't aware that Dr. Galena wouldn't be called until the trial started, and we advised the plaintiff in the court at that time that we were going to be seeking a missing witness charge. He never did come to court. Now, I believe that in cases where a treating physician has a unique insight into the most critical course of time and treatment, that physician's testimony is not cumulative, and the lack of that justifies a missing witness charge. Okay, I would also like to discuss a few of the other prejudicial errors if the court is satisfied with the missing witness. So essentially, my first point was that we were deprived of.
I just have one final question on the missing witness issue. What would be the effect of, what are we talking about here? A reversal, remand? What happens if that missing witness charge wasn't given for their
Well,
position?
it is our position that this is an extremely prejudicial error in this case, and it warrants a new trial, which is what we're asking this court to grant. Essentially, it's St. Barnabas's position that all we wanted here was a chance to fairly try our case, and we didn't get that chance. As this court may be aware, St. Barnabas Hospital is a safety net hospital serving this county's neediest, the Bronx County's neediest population. And in this trial, St. Barnabas Hospital was deprived of its ability to cross-examine the most critical damages witnesses. It was hamstrung in our attempts to cross-examine the only medical witness in the case. It was prevented from pursuing its theory of defense. It was proscribed from utilizing critical evidence on cross-examination, and it was denied critical instructions about interested in missing witnesses, which is what we were just discussing. And each of these prejudicial errors alone would be enough to warrant a new trial. The cumulative effect of them certainly is. Now, should the court get to the issue of damages, it is defendant's position additionally that the trial court erred in not significantly reducing the future damages for medical expenses, which were speculative and unsupported by the credible evidence, and as well as denying the request for a collateral source hearing. Now, as for the interested witness issue, all of the treating providers in this case had equitable liens on the proceeds of the case. Defense counsel was effectively prohibited from.
So that doesn't seem like the strongest argument to me, because that's frequently the case in all kinds of personal injury cases.
Well, Your Honor, the jury should have been able to be made aware of the fact that these witnesses were interested in the outcome of this case and that they had not yet been paid. And in fact, plaintiff's counsel brought this up on direct exam of Dr. Guy. He brought out the bills that were, it was a $43,000 bill. He said she's already paid $23,000. $20,000, $23,000 still outstanding. And then when defense counsel tried to ask about this, plaintiff's counsel said, no, 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 that's a collateral source issue. You can't get into it.
You can expand on that on rebuttal if you like. Thank you.
Thank you.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff respondent. Do you want me to start with the missing witness?
Galena doesn't testify, right? How can Dr. Guy be permitted to read a letter from Dr. Galena?
Well, because Dr. Guy, our position is that Dr. Guy was a treating physician and that he...
Dr. Guy comes on the scene 6 years later, doesn't he?
Yeah, but yes, he does, but he treated...
The real treating physician is Dr. Galena. Dr. Galena is the one who did the surgery, right?
Yes.
And
yes,
Dr. Galena says that, and according to his operating note, he says that he saw the herniated disc, right?
Right, but,
That's-
yes, Your Honor, he did. But also,
That's the treating physician about the matter that's an issue.
well, but it's not just about the cervical fusion. It's about the other injuries that that plaintiff had. In addition,
But how does that Dr. Guy do the causal connection if he didn't treat your client until 6 years later after the accident?
because Dr. Guy reviewed the evidence that's in Dr. Galina's records were in evidence.
Why don't
Dr.
you
Guy
have to make a showing of where's Dr. Galina? If it's in the record, maybe you can point me to the exact site, because I looked for your showing of his unavailability and I didn't see it.
I did not see it in the record as well. But what
That's a problem,
but that's not.
especially when we're talking about a missing witness who is in fact the treating physician.
But Dr. Guy was also the treating physician.
I don't know if by any stretch we can say, or maybe you can point me to another case where we say that the treating physician is the person who comes on the scene 6 years later.
Well, in Dukes, he didn't come in 6 years later, but in Dukes against Rotem, which is in our
Well, if he
brief.
didn't come in 6 years later, then I don't know if Dukes applies.
Well, but what Dukes stands for, and this court said, is that if the evidence is in record, if the records are in evidence, Dr. Guy testified as to the treatment and the care by Dr. Galina, and also.
Why isn't that hearsay?
Well, because he reviewed the MRIs, he saw the cervical herniations, the lumbar herniations, he treated
He
her.
testified to something that Dr. Galina said that he saw during a surgery, which is directly the herniation. How is that not hearsay?
Well, I mean, he wasn't in the back, just like I agree with you that Dr. Galina did the surgery, but Dr. Guy could still opine as to
What Dr. Galina saw during the surgery?
Well, it's in evidence. It's the record in evidence. And the treating physician can opine.
He's not the treating physician, is he?
He is a
Came on
treating.
6 years later to treat the patient, but he's not the treating physician by any stretch of our case law.
Okay. Maybe not as long as Dr. Galina, but our position is he's a treating physician. With regard to damages, I'd like to turn to that for a minute because, first of all, the entire trial.
Just to get back to one other question from my colleague, in terms of unavailability, if we find that Dr. Galina was a missing witness, where in the record could we find any information about him being unavailable?
Well, I mean, I think the point is, in the colloquy that's in the record about the missing witness, was that Dr. Galina's records are in evidence, and Dr. Guy can opine as to the treatment. And
okay.
Dr. Guy actually saw the plaintiff.
For a few times after you got the trial date. He saw her on several occasions, more than 6 years after and after you
Right, but
received the trial date.
Yes, but he also saw the plaintiff longer than Dr. Galina, and that was an issue that came up in the colloquy with the judge with regard to the inference that would be drawn. So the inference that would be drawn on a missing witness would be that his testimony would be adverse to plaintiff. And one of the arguments that was made was that it would be preposterous to think that Dr. Galina his testimony would be adverse to plaintiff when he did the cervical fusion. And that's what was this.
So the jury got to hear from Dr. Galina without Dr. Galina being there and without us knowing why Dr. Galina couldn't be there.
There's no evidence as to why he couldn't be there. That's correct.
But is there supposed to be?
Well, that's one
Under
of
our
the,
case law.
That's one of the factors. The other factor is whether it would be cumulative, and that's why I cited the Dukes case. So I probably don't have much time left, but with regard to damages, I think it's really important to highlight that this entire trial was basically poisoned by the defendant's position that there was some type of collusion and fraud that was going on that underpinned everything in this case, whether it was the post-trial motions and the trial, and that there were liens where there was no evidence of liens, that there was fraud. There was no evidence of fraud, so the motion to renew was really based on no additional evidence that they couldn't have had before. One last thing quickly. Can I just do one?
30 seconds.
We spent so much time on the missing witness charge, which I understand is significant. But with regard to the damage awards, if you look at what was estimated, almost $5 million, and the jury gave $1 million for the future medical expenses, I mean, clearly the jury could have credited the testimony of Dr. Guy with regard to her level of disability. But what I think is significant about this jury verdict is that actually they probably disregarded a lot of what he said because they didn't award future surgery, and the verdict is so
What
much
follows
lower.
from that if your supposition is correct? What inference should we draw from that?
That it was lower? That mean their verdict was so much
Well,
lower than was
I mean, maybe I'm missing the point, but you said that that means that they were skeptical of Dr. Guy's testimony to a degree, or what do you mean?
I don't mean that they were skeptical. I meant that they accepted certain portions of it, meaning that they did not award future surgery. I don't think
The question is, what legal import does that have?
I don't think it has legal import because for two reasons. One is the plaintiff at the time of the trial hadn't had the surgery yet. Maybe the jury, I can't get into their minds, didn't think that she may have needed the surgery because she didn't have the lumbar surgery yet, although she was supposed to. My point is that they were they took the evidence, they wanted to take the evidence and not just add up all the amounts that's in Dr. Dwyer's chart from Dr. Guy's life care plan and just award the amount. They took the amount, and you could see the jury notes too, that they specifically asked for the ablations and the injections, and they were careful and considerate as to what the plaintiff's damages and future care would be. I think it's an indication that they were thoughtful and not just awarded a runaway verdict.
Okay, thank you, counsel.
Thank you.
Just quickly, with respect to the future medicals, this court in Sonera versus Embassy House LLC rejected an Alley Guy opinion for future medicals, and it cited a case called Lopez versus City of New York, which is also this court 2021. The damages were rejected where they were speculative, as the plaintiff had not received such treatment for years before the trial. And in the absence of the foregoing treatment for years, it demonstrates a lack of necessity for such treatment in the future. Now here, the plaintiff had not had anywhere near the frequency of visits that Dr. Guy was suggesting. The physical therapy, 40 visits per year. She had less than 10 visits in 2021 and 2022 combined, and even before the pandemic in 18 and 19, she had approximately 15 per year. So I believe that this is also, the jury rejected future surgeries and the other awards of the need for 10 surgery visits per year, 12 physiatrist visits per year, all of these things, prescriptions. There was no evidence of any prescriptions that she was currently taking. So I believe that the record is clear that that was a very speculative award, which was appropriately which should have been rejected. With respect to the missing witness charge, I agree with this court that Dr. Guy was not the treating physician, and to allow him, as the court below did, to testify in detail about what the neurosurgery was, what was seen by Dr. Galena, conversations he had with Dr. Galena, established proximate cause, and even established proximate cause for future potential surgeries due to this adjacent segmental pathology when the levels above and below the fused level have increased pressure. So he predicted need for future neurosurgeries. This was all absolutely improper, and essentially the failure to call Dr. Galena and allow the defense its right to cross-examine him thoroughly rendered this verdict improper.
Thank you, counsel. Thank you both. People v. Coan Hernandez. Please.
Good afternoon. Sam Claflin of the Legal Aid Society for Coan Hernandez. In the 17 years since Mr. Hernandez's crimes, he's proven that his risk of reoffense is low. His rehabilitation is extraordinary. This court should grant a downward departure to level 1, considering he is almost a level 1 on
No,
points.
of course not. Please, go ahead.
When you say his 17 years, since when?
Since the offense, Your Honor.
Since the event, when was he released?
2023.
So he hasn't been out in the community for 17 years. I just want to make sure that
That's absolutely correct.
Okay.
We're focusing on the rehabilitation that he completed or did while incarcerated. He earned nearly perfect scores in the sex offender counseling and treatment program. I know that your honors hear all the
And
time.
you think that that was not, obviously we're dealing with Galati.
Yes.
And, what was not captured by the RAI. And so is it your main argument that the SOCTP performances was not captured by the RAI?
The degree to which he excelled in that program, yes, Your Honor. The guidelines at 17 say that an offender's response to treatment, if exceptional, can be the basis for a downward departure. And I know Your Honors hear that argument all the time, but the difference here is that we have Mr. Hernandez's scores in the record, and they back it up. They are not just good, they are almost perfect. He proved through those scores exceptional insight into his behavior and how to avoid it in the future. His risk is low. Next, he earned a bachelor's degree from Bard College while he was incarcerated. This court has recognized academic achievement as a basis for downward departure in Batiste and Williams. And in Williams, this court granted a downward departure.
Counsel,
citing-
these are all laudable efforts by your client, but they're captured by the risk assessment tool, no?
So in
Participation in sex offender treatment, correct?
mere participation is captured, yes. But exceptional response is not captured. And again, the guidelines make that clear at page 17. And here, Mr. Hernandez earned essentially perfect scores in the treatment program.
So is it your position that when someone does well in the program, which I would imagine we would expect that they would do, that we should grant downward departures?
It's a significant factor to be weighed in the case, Your Honor. And
How do we weigh that against the third gelati factor?
right. So naturally, we're looking at the crime here and the
I'm
conduct.
looking at the totality of the circumstances.
Yes, of course, exactly. And I imagine we're going to hear about the offense when the prosecution speaks to this court in a moment. Mr. Hernandez made terrible choices 17 years ago. There's no denying that at all. Thankfully, he is a low risk to the community now because he's done everything we would hope that an incarcerated person would do during their time inside. Again, a bachelor's degree is a recognized basis for downward departure, as this court said in Batiste and Williams. This court granted a downward departure, in part on that basis in Williams.
In part.
In
'Cause
part,
I think
that's
Williams
correct.
had a lot more factors than just academic achievement.
Yes, Your Honor, that's right. But here, Mr. Hernandez had the perfect SOCTP scores, which Mr. Williams did not have. I also want to frame this in terms of where we are on the RAI. Mr. Hernandez is almost a level 1 already.
In the RAI that was submitted by the board, he was assessed 90 points. However, during the hearing, the court only assessed 80 points. What's the significance of that?
That's absolutely right. The reduction in those 10 points was actually something that the prosecution came down on because
They were misdemeanors.
exactly, it was a marijuana misdemeanor from a long time ago. And in fact, today, that wouldn't even be a crime in this state. So Mr. Hernandez was scored 80 points on the RAI in the level 2 range, which runs from 75 to 105. His near level 1 assessment then is the starting point. And I submit that
Has this court had the opportunity to look at lower end assessment, and how do we view that?
I'm glad you
Is
asked,
that
Your
a
Honor.
basis for a further downward departure?
I'm so glad you asked.
Well, thank you.
I don't think this court has opined directly either way on that question, but here's what I have to say about that. The second department routinely analyzes departures that way. We cite 5 or 6 cases in our brief where they do the analysis exactly like that. And if I may just...
How do we look at that when we talk about the second department has done it?
Yeah, so again, I think the second department's analysis is persuasive there, and I'll tell you why. I think what I'm asking for is really self-evident from the way that RAI scoring works, because anytime a party asks for a departure, you can actually see how many points that departure would be equivalent to. It's really just there in the way that the board set up the scoring on the RAI. And so here we're requesting for a 10-point equivalent departure. I'll speak to you again on rebuttal.
Hold on, counsel.
Oh, please.
Was that a joke?
No, I'm good.
Okay. Thank you, please.
Thank you.
You have time in rebuttal.
Good afternoon. May it please the court. Skylar Siebert for the people. Your Honors, defendant participated in a masked home invasion where he violently restrained, pistol whipped, and tortured 4 victims. He then subjected the sole female victim to an hours-long spree of sexual abuse.
That all happened in 2009. It was horrible.
Yes.
That was 2009. A lot of water under the bridge since then. Now we're trying to figure out about his future dangerousness and possible recidivism. So let's talk about that.
Yes, Your Honor. The RAI and the SORA court considered and credited all of the mitigating factors defense now is setting forth to you and citing. The
Well, he
defendant
cited that the one mitigating factor was this exceptional performance in the treatment program. In your estimation, based on what you have of the record, was the participation exceptional?
No, Your Honor, for two reasons. The defendant's participation merely comes down to 4 progress notes, and those 4 progress notes just simply demonstrate that the defendant was involved and engaged in the treatment program, which is, as the court noted before, exactly what he's supposed to be doing while in that treatment program. Second, the defendant was placed in a moderate to high risk level 1 program, which is a 9 to 12-month program, and he completed a third of that program, and we have no idea if he would have even completed the entire program, seeing as we only have 4 progress notes. Similarly, the RAI captures the employment and family support, which is considered by factor 15, and the defendant's education, which is factored into factor 13. I also want to address People v. Williams briefly. That case cannot be compared to this case. Mr. Williams committed the crime while under the influence of PCP, marijuana, and alcohol. While incarcerated, he received his GED, his associates, 2 bachelor's degrees, was taking steps to get his law degree, completed 4 treatment programs, and was a program facilitator for alternative to violence programs. He also strengthened his community ties, and he had support from corrections officers. Mr. Williams' rehabilitative steps cannot be compared to the defendant here. In any event, the violent nature of the crime and the harm caused by any potential reoffense outweigh the mitigating factors. As such, we ask that you affirm. If there are no further questions, we rest on our briefs. Thank you.
Counsel.
Mr. Hernandez was not just involved and engaged in the program. He scored a 15 out of 16 2 months in a row, and then a 16 out of 16 the next 2 months, showing improvement and literal perfect
Completed
scores.
the entire program?
He did not, Your Honor. But what's uncontroverted in the record is that the late start was not his fault. We submitted a correspondence from the Department of Corrections acknowledging that he never refused. So really what we have here is a systemic failure on the part of the department to get him into the program at the standard starting time. And I think his perfect scores actually are all the more impressive given his truncated abridged time in that program. As to academic achievement, the prosecution's wrong that it's accounted for by the RAI. Again, Batiste and Williams make that clear. Regardless, the fact
So
that
there is no education component in the RAI?
no, factor 13 is about disciplinary history. I think you'll find if you revisit the factor 13 in the guidelines, it really speaks directly to disciplinary history alone. And even if something like a GED completion, we could say was considered. Mr. Hernandez here earned a bachelor's degree from Bard College.
GED, then he went on to get other degrees and pursued it, and also the leadership position. It's not like Williams.
So one other thing I want to say about Williams. Williams actually had other aggravating factors that are not present here. Williams had a very extensive, violent criminal history. Mr. Hernandez does not. Further, the downward departure in Williams was equivalent to 30 points, which is 3 times the degree of departure we are requesting, 10 points here. And I submit again that Mr. Hernandez did everything we hope someone would do while he was incarcerated. His risk is low. This court should adjudicate him a level 1. Thank you so much.
Thank you, counsel. Thank you both. Suazo v. Charles Schwab and Company.
May it please the court, Gaurav Talwar for respondent Charles Schwab. We submit that the decision of the Supreme Court from June 25, 2025 should be, which granted the stay and compelled arbitration should be affirmed. All of the claims asserted by the appellants here arise out of their account with Charles Schwab, which is subject to the account agreement, which has a mandatory arbitration provision. Appellants have not identified any basis to overturn that arbitration provision, and the arbitration provision at issue here has been routinely upheld by state and federal courts. If there are no further questions from the panel, I will rest on our submissions.
Thank you, counsel.
Thank you.
Kay Vibenchik.
Good afternoon.
Please.
Good afternoon. Andreas Koutstakis, David Off Hutcher, and Citron for the plaintiff appellant. Your Honor, the trial court erred in 3 distinct and independent, sufficient for reversals. Independent,
Also,
yes.
the claims that arise prior to September 13th, 2020, why aren't they barred by the statute of limitations when they involve different actors, different acts? How can you say that it's continuing so as to bring them into the statute of limitations?
Well, first, Your Honor, they're not different actors. It's the same actors. And there's a distinction between the continuing violation doctrine and background evidence doctrine. And we submit to the court that the background evidence doctrine was completely ignored in this case. And that caused a ripple effect with respect to the other grounds. So beginning with the background evidence, all of that, including the not having children background context that we put in, and it's clearly stated this is not a basis for discrimination. The whole entire story leads up to the ultimate terminating event, the termination in March of 2023. The background establishes what is actually happening here between the two controlling individuals and the company. This is a history of it. So once you reach the ripe age or we're done with your service, at that point there's a termination. But the things that happened before are certainly relevant. Petit allows it, series of cases that followed allow it, and Your Honor, there was a case yesterday that also looks at incidents before the claim period, and that's Farmers, which is not obviously cited.
But counsel, doesn't it have to be some continuing conduct versus two discrete incidents in order for that continuing doctrine to apply?
Well, Your Honor, there are
because you're talking about background, right? There's background, and then there's conduct that continues over a space of time that's more than just discrete background information.
Yes, Your Honor. Well, it doesn't have to be connected. Our position is that it doesn't have to be connected. It shows a pattern, a type of behavior, both in terms of gender and age, ultimately. But the gender is what's happened over time. So as long as she did what she was told until she raised her voice, at that point, that was when she was terminated. So everything led to the events of March, and this just goes back to this was a history of it.
Counsel, turning to the post-2020 events, the decrease in equity interest, that's the subject of a separate lawsuit, is it not?
Yes, Your Honor, and Justice Mary Rosado is also the judge on that case. So the plaintiff in this case is an employee, receives a paycheck, and is also a shareholder of a number of different entities, one of which is not M&M2. M&M2 is the management entity through which she was kind of put in place just there, but she's been with the company since she was 23 years old. Fast forward, once she reached the later ages, and she raised a complaint about why is this being devalued, and the position all of a sudden becomes, well, we want to make room for younger blood, which on its face is
that lawsuit, the other lawsuit in front of Justice Rosado is still around, right?
It's still pending, Your Honor, yes. And so there's distinct rights as a shareholder or member and versus as an employee. In this case, that's our position, and the case law supports that as well. The last thing I would state, Your Honor, is there's a liberal pleading standard here, and that's not what was applied. By ignoring the background evidence, isolating only the April 2021 incident, ignoring entirely the March 2023, and viewing this entirely just as a shareholder dispute, which that's what it looks like if you ignore the background evidence and have no context, the case was dismissed, the complaint was dismissed. When you take it as a whole, correctly view the shareholder rights as separate from the employee rights, there's a on-your-face, facially sufficient complaint, 20-page complaint alleging details and a history going back 15 years.
Thank you, counsel.
Yep.
Good afternoon. May it please the court. I'm Felice Eckelman from Jackson Lewis. I represent all of the respondents. As the court has already noted, this is a business dispute disguised as a discrimination claim.
I don't know if you noted that.
I'm sorry.
I think we were asking questions.
Understood.
And it is a pleading motion, to pick up on the thread that was the last thing that your colleague was talking about. It's a pleading motion. So here, isn't there enough about sex and age discrimination to get past 3211?
There's nothing about age discrimination to
doesn't-
get past a motion.
Doesn't plaintiff allege that only months before she's terminated, Banchik and Ash talked to her about creating more opportunity for young people and for them to take over positions from senior people? Doesn't that provide an inference of age discrimination?
The allegation in the complaint is that they are alleged to have said that they want to provide more opportunities for young people to buy shares. That has nothing to do with her employment. It has to do with her status as a shareholder. So if you look at all of the allegation of the complaint that are not time barred, the one from April 2021 is that the defendants refused to sell her equity and offered the equity to a male. The second claim in August of 22 is that she requested a raise and an opportunity to buy points. There's no allegation that the raise was denied. We don't know what happened with that. And then the third allegation,
Would
which
we
is not
find
dated.
that out maybe in discovery? Because this, again, as my colleague pointed out, is a pleading motion.
That is correct, but there isn't enough to move this towards discovery because there have to be facts.
She's alleging she's part of a protected class. There was some adverse employment action.
The adverse employment action is the termination in March of 2023. These allegations are not connected either temporally or contextually to the termination. The only allegation about the termination is that plaintiff was replaced by a male. That's not enough. This certainly has nothing to do with age discrimination.
Aren't there also allegations about males receiving higher raises and more opportunities to earn commissions?
There is an allegation about a raise and a commission that is not time barred. That is correct.
So why doesn't that again, as it being a pleading motion, that it gets the gender discrimination claim?
Because there's no allegation that the plaintiff was denied a raise. She just says that she was asked for a raise. There's no allegation as to why the men were entitled to earn commissions. Perhaps they were in a different position.
There is an allegation that the males received higher raises.
There's an allegation that the men received a 50% raise. That is an allegation. We don't know anything about that. The complaint is bare bones. It doesn't talk about why these men received a 50% raise, which men they are, when this 50% raise was allegedly provided, what their salary
She was
was.
treated less than her male counterparts with spouses and family. Doesn't that give an inference, support an inference of gender discrimination?
I'm just want to look at the complaint for one moment.
Again, we're at the lenient.
The allegation is in paragraph 24th of the complaint. In or around August 2022, plaintiff met with, or appellant met with defendant Banchik to request a raise and an opportunity to buy equity points. Plaintiff noted that two other equity partners had received 50% raises post-pandemic and had received opportunity to earn commission. Both equity partners had young children.
Why isn't that fair notice of her allegations? They don't have to be specific, they just have to provide fair notice.
Well, actually, I'm looking, and it doesn't even indicate that these were men, just that they're other equity partners. I'm looking at paragraph 24. Just that they don't, just that they had young children. And not being being a childless adult is not a protected class under the law. I'm sorry if I missed a question.
Thank you, counsel.
The court properly dismissed the three earlier allegations as time barred. They don't they don't constitute evidence of a continuing unlawful practice, and the court should affirm the lower court's dismissal of the complaint in its entirety. Thank you.
Thank you.
Your Honor, Respondent's counsel indicated that this was just about, to buy shares. The bottom line is the objection was raised to Banchik and Ash, and ultimately, specifically, that that should not be the basis for devaluing the shares. Consequences, the damages for her shareholder action are the devaluation of the shares. What are they actually worth versus what someone was bought in for, right? And her not receiving the total value. The damages for her being fired the day after, a week after she raised the complaint in front of everyone at a board meeting, at an annual meeting, is an employment consequence. She no longer receives that money. Since March of 23, she hasn't been receiving that pay, but she has been receiving her distributions while the case is pending. So those are completely distinct. I do agree, Your Honors, that the fair notice pleading is what's the standard here, and that's one of our main points. And all of the case law supports it. Vig, Hernandez, Crookendale, even the case yesterday from Farmer. These are all focusing on the stage of the case where we're at, which is pleading, and not something later like motion for summary judgment. That's it, Your Honor. If you have any questions, I'm happy to answer.
Thank you, counsel. Thank you both.
Thank you.
RC v. Jaffe.
Thank you. May it please the court. John Giuffre, Giuffre Law Offices for plaintiffs' appellants. Our argument is basically there were two qualified experts that were sufficient to deny summary judgment to the two physician defendants and to the physician group. These same experts provided evidence of departures concerning the delivery.
Does the expert, talking about the failure to call a maternal fetal medicine expert when your client presented on March 19th?
Yes.
Does your expert say, and if you can cite me chapter and verse, that would be great. Does he say that that was a departure? Yes. Okay. Where? If it's easy to get, I don't want you taking up all your oral argument time.
Are you referring to page 4997? 4997?
Yes. Where he's.
So where on that page does he call it a departure?
Says, moreover, there is no, in the middle of the page.
Moreover, there is no
Yes.
indication that an MFM, maternal fetal medicine consult, was called to consult on the high risk, but he doesn't call it a departure. It's like he's acknowledging or stating this wasn't done. Unlike when you're talking about a departure on page 4975, it was a departure. Departed from good and accepted standards of medical and obstetrical care and practice as follows.
I wonder, you can answer him first, and I have a follow-up question.
I don't think within the body of the expert's affirmation it actually says the failure to call the MFM consultant was a departure. I think it's implied in here that there were two departures: the failure to deliver and the failure to consult with an MFM specialist.
There's no explanation of what a maternal fetal medicine specialist would have had to say about this, or why you needed a maternal fetal medicine specialist, or what that specialty encompasses, other than what the doctors that were already on the case may have known about the condition.
Yes, you're correct.
I wonder if you could maybe talk a little bit more about what's on page 4997 of the record when we're talking about what happened at NYU in not having the MFM consultant. And then it goes on further to discuss other things that occurred that might have been departures, leading into page 4998 of the record.
Sure. So the essence of the departures, the essence of the departure, the key one was the failure to deliver the twins on March 19th when Mrs. Wiseman, Mrs. Colasanti, Miss Wiseman, presented.
Would that have been attributable to NYU, or are the allegations that that is in some way attributable to NYU?
That is, because when she went in through the emergency room, it is not clear from the records that Dr. Roshan participated in any way in her care during the time she was in the ER. Mrs. Rachel Wiseman had no knowledge that Dr. Migotsky was an employee of Roche Maternal Fetal Medicine, PLLC. He was provided by the hospital, and further, there's no indication that he even examined his patient, Dr. Migotsky, in the hospital that night. The only indication is by Dr. Honart, the second-year resident, was that she discussed the case with Dr. Migotsky.
Let me just ask you a question, because the NYU doctors and physicians aren't specifically named by name inside the pleading. It refers, the bill of particulars refers to the medical chart. Do you want to discuss that?
Sure. When we orally argued the case, the question was, well, what did NYU do wrong? That was the big question. And I fell back on my affirmation of they failed to deliver the twins that night. And I did talk about the failure to get a maternal fetal medicine consultation. But the failure to name names is difficult in light of the fact that we don't know who did what.
Counsel, how do you square that with our decision in 2021 in the Gamba-Corta case? Cited by the defendants, Gamba-Corta versus Giordano. It's cited in their brief.
I think I dealt with Gamba-Court in my reply brief.
Okay, but how do you square your failure to specifically name the doctors in your pleadings with that case and us being able to, for you being able to sustain your burden on a summary judgment motion without naming the specific doctors?
I think the records are vague enough and have enough problems in light of, especially in light of the fact that there are post-ER documentation imported into the ER and admission from March 19th.
But this case has been pending for a while. We're at summary judgment stage. You've done the discovery. Why is it that you don't have that information readily available to submit in response to the summary judgment motion?
I just wasn't clear who did what in the hospital on March 19th. From a trial perspective.
I'm just following up on what Justice Michael said. The argument in your brief is that you can't tell who was the decision maker from the records. But then, isn't it incumbent on a plaintiff to take the EBTs of those physicians?
Well,
or gather information to find out who the decision makers were somehow.
It might be, but sometimes it's best for trial presentation to leave it on the defendant.
But counsel, if you're asserting a claim against NYU, you need to be able, especially if there's a summary judgment motion, we need to be able to understand what you're saying NYU actually did wrong, or what you're alleging, that there are enough facts alleged for
They
that.
discharged her on March 19th inside of 2 hours without delivering the twins. They missed a golden opportunity. Based on her presentation, they should have delivered her.
The discharge summary said that Dr. Roshan authorized the discharge.
Sure. Yeah, Dr. Roshan had no memory of it. Dr. Roshan also testified.
Whether or not he has a memory of it 2 years or 4 years or 6 years later, that's what the record shows. His lack of a memory of it doesn't mean that it's inaccurate.
Well, those same records have numerous people authorizing the discharge, including Ann Honart, the second-year resident, and
I'm sorry, you're saying that those records have additional people from NYU authorizing the discharge?
Yeah, she signed off on it.
Doesn't it that Dr. Honan signed off on it, and in consultation with Dr. Miglarski, but it says authorized by Dr. Roshan.
Yes, there are other problems with the NYU
I mean, the record unequivocally states that it was authorized by Dr. Roshan, and it's true that he doesn't remember it. You cite to that in your brief, and the record says that he doesn't remember, but
There's
the
another
record
place.
says what the record says.
Dr. Roshan was specifically asked, did you order any testing while she was at NYU that night? And he said
Let me ask you
no.
something else. I know your red light is on. If the C-section was to be done that night, who is going to do the C-section?
Dr. Mikotsky was an OB, perfectly board certified, perfectly capable of performing that C-section.
You mean her doctors, the group that she had been treating with? Was Dr. Miglarski a member of that group?
He was an employee of the
The
group.
record shows that he was a member of
But he was working at NYU, right?
Record does not show that he was a member of the group.
The
Dr.
testimony-
Roshan testified about that.
Testimony from Dr. Roshan is that he was affiliated with Dr. Roshan's group.
Correct.
But you mean that the C-section, which had been scheduled either with Dr. Roshan or with Dr. Jaffe, was going to be done by an NYU doctor that night?
Right,
that-
that's what I'm
Well,
saying.
is that
That's
what
exactly-
typically happens?
Well, your allegation is that if it's an emergency surgery, right, and she presents, then because you're at an ER, the individual at an ER who can do that type of surgery was that doctor, right?
Yes.
And that's what should have happened under the
That's
standard?
what we're saying. They should have delivered her right
But
then
there's
and
no
there.
allegation here that that was that type of an emergency, that there isn't time for the patient's usual doctor to get to the hospital, do the delivery. I mean, this wasn't a C-section which had to be done that moment. I understand you say it had to be done that night, but it wasn't an emergency situation that Dr. Miglarski should have immediately taken her into the operating room.
That's our position based on
Well, we
her
don't know. They
presentation.
released her after 2 hours, correct?
Pardon me?
We won't know if it was an emergency. They let her go after 2 hours,
Well,
correct?
it was a very brief. They did let her go. The testimony was as soon as they heard the heartbeats, they basically sent her on her way. Dr. Roshan, in the record, says there's a place where he actually orders a glucose test. When he was asked at his deposition, did you order any testing? He said no.
I mean, the thing about it, we really need to look at what's in the expert affirmation, right? And whether or not the expert affirmation supports a question of fact so we could push this to trial. And if we're looking at that in terms of NYU, when we're going from pages 4996 to 4998 of the record, does your plaintiff's expert submit enough to raise an issue of fact?
I respectfully submit he does. He's very specific. There was no benefit whatsoever. These were monodi twins. They should have really been delivered in 36 to 37
Thank you.
weeks.
We've gone over, because there are a lot of issues in this case, but
Yeah.
you'll have time in rebuttal. Thank you.
All right, thank you, Judge.
Good afternoon, Your Honors. May it please the Court. I'm Barbara Goldberg. I represent NYU. I have a lot of issues to address, obviously, but I'd like to go back to the beginning, that NYU is an institution. An institution can only act and treat patients through personnel. And it's our position that it's not enough for the plaintiff to argue.
Is Dr. Miglarski your personnel?
My understanding, Your Honor, is that based on Dr. Roshan's testimony, this is at page 4760 of the record, Dr. Miglarski is an OBGYN who is an employee of Roche Maternal Medicine, maternal fetal medicine. There's no indication in the record that I've seen that he's an employee of NYU, and I think it would be almost mutually inconsistent that he's an employee.
I think there's something in the record which says he was a covering doctor. Was he the covering doctor for NYU, or was he the covering doctor for Roshan?
I think it is a fair inference that he was the covering doctor for Roshan, because the plaintiff herself testified that when she went to the hospital, that she called called the group. This is at page 3731. She testified that she called.
Well, I mean, is the plaintiff really the person who's best to establish where Medosky came from or what he was doing there? I understand what you're trying to get to, and you're saying it's a fair inference, but we're here at summary judgment, right? Are we going to let this case go to trial or not? And are we doing that based upon fair inferences on what the plaintiff should have known? I don't know if that's the appropriate standard.
Oh, I think, Your Honor, there's no question that we established our prima facie entitlement to summary judgment.
Right, but we're talking about the issue of fact, was it raised or not?
Right, and I don't think an issue of fact has been raised because the plaintiff, what we talked about, page 4997 of the record, there was never an indication, a specific assertion by plaintiff's expert that it was a departure not to call the maternal fetal medicine expert. And I think the cases
But it also goes on to talk about whether or not the twins should have been delivered that night. And I mean, it's quite detailed. It's not as if it's conclusory and there's one sentence. It's actually quite detailed on those 3 pages.
Well, the expert ignores a key fact because the expert OBGYN for the plaintiff asserts on several occasions that the mother's gestational diabetes was poorly controlled. In fact, by that point, it was well controlled. She was on glyburide. All the tests performed that night were reassuring. The purported decrease in fetal movement had resolved on her admission to triage. That's in the hospital record. The fetal heartbeats, the beats per minute, were well within the normal range.
But the expert's affirmation is very clear on the departure in that the delivery should have taken place between the 34th and the 36th week, or certainly by the 37th week, and therefore, when the plaintiff came in, the C-section should have been done that night. But NYU only operates through employees. The institution itself doesn't do anything.
And
there's no question that NYU had on staff that night, and it's an NYU person, Dr. Honan. Now, we don't know whether Dr. Magatsky there are indications that Dr. Magatsky was part of Roshan, but if Magatsky was part of Roshan or Magatsky was part of NYU, in either event, the expert needed to come forward and say, when you're saying that NYU was NYU negligent in what Dr. Honan did? Was NYU negligent in what Dr. Magatsky did? This is not a pleading motion. I mean, this is an over 5,000-page record. There's been a lot of discovery here. There is authority which says that when you're seeking to hold an institution liable, you have to name who at the hospital did something negligent.
That's absolutely correct, Your Honor, and those are the 2 cases that we cited, the Gambacorta case, which was referenced earlier, and the Hardy case. And I would also point out, I know my time is up, but I'd also
is it an answer for the plaintiff to say, well, we don't know who it was at NYU, which is...
No, it's not sufficient for the plaintiff to do that, and I think those cases make it very clear, and I also think it's important to emphasize that Dr. Honan
Why isn't it sufficient for the plaintiff to direct where they're talking about in their bill of particulars, in the medical charts, it then says who did what?
Because it's basically...
Because it's NYU's medical records, we're not disputing that.
I know, Your Honor, but I think it's really asking us to guess because...
And I went back and I looked at the bill of particulars in the Gambara case, and it's different than what we have here. It doesn't necessarily make that reference.
Counsel, and to confirm, NYU never filed the demand for a bill of particulars, correct?
We did. There were several bills of particulars as...
That NYU filed.
NYU, and the final one, the second supplemental bill of particulars, I think we had asked to identify the employees, and I think the plaintiff's response in the second supplemental bill of particulars was that they're the people named in the chart. But again, I don't think that's sufficient, even though...
But anyhow, the issue today is not about the bill of particulars. The issue is whether, if you've made out a prima facie case that NYU is not negligent, whether the affirmation submitted in opposition to your prima facie case creates an issue of fact when you don't name who it is at NYU did something wrong. After all, the expert goes through all of these NYU records that the expert went through in order to render his or her opinion, and NYU actually doesn't know more about it than the records show.
That's absolutely correct, Your Honor, and that's one of the key reasons why I submit that their opposition was insufficient to raise an issue of fact, and accordingly, the court correctly granted a summary judgment in favor of NYU. And may I just make one more point very, very briefly?
30 seconds, counsel.
I'm sorry?
30 seconds.
Thank you, Your Honor. Dr. Honart was a resident. She was a PGY2, and accordingly, her obligation was to follow the instructions of attending physicians. In this case, it's clear that this was a private patient. She was followed by Dr. Roshan, Dr. Jaffe, and Roshan MFM, and this is not a situation where Dr. Honart would have had any independent decision-making authority.
Where in the record you just said that she had an obligation to follow the directions of the...
That's case law, Your Honor. Walter against Betancourt is the case that we cited for that a resident is shielded from liability if he or she follows the instructions and directions.
Counsel, the Gambacorta case that you cited to, that dealt with references to identifying the treating physician in the complaint and bill of particulars, right?
That's correct, Your
So
Honor.
we're not only and solely looking at an expert affidavit to raise a question of fact, right? That's
I
based
think
on a case you cited, right?
But I think that in this type of case, it's incumbent upon the Gambacorta said a hospital cannot be held vicariously liable for the acts of a physician whom plaintiff failed to identify in the complaint or bill of particulars as a person for whose negligence the hospital would be liable. But here, there is nothing in the expert affirmations as to who at NYU allegedly departed from accepted practice. And I think for that reason, the opposition is insufficient.
Thank you, counsel.
Thank you, Your Honor.
Very briefly, first of all, there's an abnormal glucose result in the chart at page 2193. It's a point of contact testing POCT glucose. It comes out low.
Counsel, the ultimate question here in terms of NYU is, did you identify an individual at NYU who you're alleging departed from the standard of care and in some bill of particulars or with respect to the expert affidavit? Can you just succinctly tell us where that happened?
It did not. It did not. And I think NYU was never able to articulate by any review of their records who was in charge of this patient's care.
The question is because it's your case against NYU, and the question is whether, in fact, you were able to do that. If you raised a question of fact regarding who was the agent of NYU for whom you're suing.
I cannot tell who made the decision to discharge this woman after only 2 hours. And I've been doing medical malpractice work for 38 years. I've never seen electronic medical records that ported in post-event treatment.
Right, but you understand that the issue with that then is how are we able to say that you've raised a question of fact regarding the liability of NYU if we can't point to an agent of NYU? That's what I was asking you about.
She enters NYU under Maduba. She's entitled to rely on the doctors that are assigned to her care. There are a number of those doctors named in the chart. Who is actually in charge? I can't tell. I don't even know. The
problem is that she also has her own private physician who is in charge of this pregnancy, who apparently has privileges to practice at NYU, which is how this whole thing comes about.
In my reply brief, I was very clear. If Dr. Roshan had testified, I told them to discharge her. If there was something in either chart that said, I was spoken to and I authorized the discharge,
Well, the record does show that it was authorized by Dr. Roshan.
But the record...
It's true that he says he doesn't remember, but the record does show that it's authorized by Dr. Roshan.
But the same record also shows that he ordered the glucose test and he denied doing it.
Justice Pittsburgh.
The discovery's been completed in this case. When you were reviewing the medical records and you weren't able to tell who did what at NYU, would that have been something that maybe you could have explored during discovery?
There would have been nothing preventing me from exploring it. I don't know if it would have been trial tactic-wise, I would have necessarily done it, but yes, I would have had the opportunity to do that.
Thank you, counsel. Thank you both.
Okay, thank you.
CMB Export Infrastructure Investment Group, v. Montcalm.
Good afternoon. May it please the court. Matt Parrott, Fried Frank for defendant appellants Montcalm and Rubin Brothers. It's well established that attorney's fees that are incurred as a result of a wrongfully issued preliminary injunction are recoverable from an undertaking issued pursuant to CPLR 6312. Here, the court held that the appellants are entitled to recover attorney's fees that are directly related to their opposition to the preliminary injunction motion and their motion to renew that opposition and the appeal on the preliminary injunction motion. But the court, we would respectfully submit, wrongly held that we're not entitled to recover fees relating to challenging the motion to dismiss, the motion to renew on the motion to dismiss, discovery, and the other appeals in the case. The test here for determining whether those other work streams are recoverable under the undertaking is, did they involve issues that were inseparable from the issues on the preliminary injunction? And here, if you look at the lower court's decision in the preliminary injunction, it set forth what the basis was for granting the preliminary injunction. That was the first decision that was issued in the case. And subsequently, the court issued its motion to dismiss. In the motion to dismiss, the court said that—
That was weeks later, after the issuance of the preliminary injunction, correct?
Correct. And the court referred to the decision on the preliminary injunction, which it said necessarily required that the motion to dismiss that had been filed be denied. And because of that, all of the litigation relating to the motion to dismiss, the appeals, everything involved the same issues. If you look at the heart of what the case was here, the allegations in the injunction motion, in the complaint that was ultimately dismissed on appeal, all the discovery, it all revolved around this theory that the appellants had concealed the existence of an agreement that prejudiced the mezzanine lender in its ability to get repaid in connection with its loan. And so just a few weeks after the preliminary injunction
right, it came up in the California case, and the term sheet was— the term sheet, is that the correct term?
The term sheet was disclosed.
Right, and there's some ambivalence, ambiguity of that. I know you don't think so.
Well, there was an email.
But, all right, it happened, and so we're here now to determine what should be, what they should pay for obtaining this preliminary injunction.
Correct, and so
let me talk about interest, because you do ask for interest, right?
Yes.
Okay, so they say that your claim for interest fails. They say that the argument is half-baked, actually, because your client would not have collected interest because the project's, the collateral had already been wiped out by the senior loan, the most senior loan, the Chase loan. And so, you know, there was nothing there would be no interest to collect. It had all been depleted. What do you say about that?
So what happened, Your Honor, is that the injunction was issued. We were prevented from doing the UCC foreclosure on the $1.5 billion senior mezzanine loan. And then within about 5 weeks, there was a foreclosure on the senior loan, and a portion of the mortgage property was sold for just over $1 billion. But there was I think there was like 180 or so units that weren't sold.
So there was money left over for you to be paid interest, is what
there was money that was left in the collateral package. But Your Honor, there's a case that's actually specifically on point here. It's the In re 85 Flatbush case, 2024 Westlaw 2965246. We raised it in front of the motion court on our request to recover the bond. And the case is really, it's the only case we found that was on all fours with this fact pattern. In that case, like here, a mezzanine lender sought and obtained a stay of the senior lender's planned $92 million bankruptcy sale of mortgaged property on a defaulted senior loan. Like here, the court ordered a $5 million bond to be posted during the pendency of the appeal relating to the senior mortgage lender's ability to do that sale. And when the stay was lifted, the senior lender was awarded the entire $5 million bond because it showed that over $5 million in default interest had accrued during the pendency of the stay.
That's in Ray Flatbush, the bankruptcy case.
Correct,
Okay.
the federal court case. So our position is that the outcome should be no different here. The motion court said there's no proof that there's damages because of the continued accrual of interest, but Rubin Brothers, its investors, they're getting, every month, they're getting financial statements showing this growing unrecoverable balance. The injunction stayed in place until January 2024. That was over $200 million. Are we supposed to tell them that that's not damages? Of course not. We would submit that that case is on point, and I know my time is almost up, but on the attorney's fees question, I can walk through the different categories that are in the papers.
Why don't you do that on rebuttal, counsel? Thank you.
Good afternoon, and may it please the court. Jonathan Preziosi, Louis Brisbois, appearing pro hoc vijay for the respondent, and thank you for the privilege of being permitted to argue this afternoon. I wanted to begin by making a couple of corrections that I think go right to the point. I think my friend mistakenly stated in the beginning of argument that Justice Bannon had allowed the appellants to obtain recovery against the bond for the cost associated with opposing the injunction. She did not do that. The cost of opposing the injunction are as a matter of law, not damages sustained as the result of a grant of the injunction. Instead, the court permitted the respondents, defendants, recovery against the $5 million bond for the costs of vacating the preliminary injunction. So,
Right. So it's the appeals, it's the motion to renew.
yes, it was the motion to vacate, the motion
You've
to
heard the
renew.
argument, you know the argument, you tried to meet it in your briefs. They say this is all intertwined, the need for discovery, the necessity of bringing this motion to dismiss, the fact that the court referred to its order on the preliminary injunction in denying the motion to dismiss.
Yes,
How
that's
do we
where,
disentangle this?
thank you, Your Honor. And that's where the logic falls through. The question is not whether the issues overlap. The question is what costs were necessary to vacate the preliminary injunction. The motion to vacate the preliminary injunction and the appeal on the denial of that motion were sufficient to vacate the preliminary injunction. The case did not need to be dismissed for failure to state a claim in order to vacate the injunction. And the Republic of Croatia case, I think, is a very good illustration of these principles. In that case, a preliminary injunction was entered. The case went to a trial on the demand for a permanent injunction. And there was a full trial, and as a result of the trial, the case was dismissed, the injunction was dissolved. So that's a case in which the fees associated with litigating the case through trial were necessary to vacate the injunction. Here, again, the motion to dismiss and the appeal from the motion to dismiss was in no way, shape, or form necessary to vacate the injunction. It was the appeal from the denial.
Yeah, but when you want to limit it strictly to the preliminary injunction, now the participation agreement that showed that your position was untenable, that emerged in discovery in a different action.
It did.
And that's what has to force the vacatur of the preliminary injunction. Shouldn't they be entitled to the counsel fees for that?
Your Honor, your question is as it relates to discovery? The costs associated with conducting that discovery?
Yeah.
Yes, I would concede that. Now, if I could just make a point, though, about that, that discovery was limited to a document demand that was served served a week before the hearing in California, and that was the application to enjoin the senior loan foreclosure. and documents were produced a day or two before that hearing. So whatever that was, it was limited, and that was another problem with the application against the bond, is that Fried Frank's invoices as they were submitted to the court were all block billing. We didn't see invoices from California in the California litigation. The court only saw the invoices from the New York litigation, and they were all block billed, and the court couldn't discern what was associated with that discovery, what was associated with simply with the applications to vacate the default as opposed to the motion to dismiss. And to the court's credit, the court has allowed, in fact, the appellants that additional opportunity to now go into more detail in their bills and attempt to isolate what fees and costs were associated directly with moving to vacate the injunction and the appeal. So as it relates to the motion to dismiss, which was really a bulk of the claims and a bulk of the bills, I would submit again, those costs are not damages sustained as the result of a preliminary injunction, because the motion to dismiss did not need to be filed in order to vacate the injunction. The motion to vacate and the appeal were sufficient and necessary to do that. I wanted to make one other correction. The In re Flatbush case is in no way on all fours with the facts in this case. We pointed out in our opposition brief that In re Flatbush did not involve a situation where independently the foreclosing lender had entered into a forbearance agreement with the borrower, and that was the case here. The Rubin brothers, this was both the senior lender and the senior mezzanine lender, in April of 2023, entered into a forbearance agreement with the project borrowers, agreeing that it would not foreclose on the property, on the senior mezzanine loan, for a year, even if the injunction was vacated in the interim. So the court properly concluded that it was, if anything, it would have been the forbearance agreement as an independent cause that would have precluded any foreclosure during the time
You
period.
unpack that in your brief. Thank you.
Okay, thank you, Your Honor.
Thank you, Your Honors. I'll try to be brief. So to the extent that there's a concession that the term sheet and discovery relating to the term sheet is something that should be or could be recoverable under the undertaking, that shows that the motion court decision should be reversed. And so the question is, how, it was a reference to block billing. Who's going to determine what billing is or is not appropriately recoverable from the undertaking? Well, that's the job of the referee. And because of the court's decision, narrowly limiting the recovery just to time that was incurred in seeking to vacate the preliminary injunction, and that line of work, that's reversible error. We would submit that if you look at the categories that we laid out in our papers, this court ultimately unanimously reversed the lower court decision. It did so in a decision that consolidated four appeals. There was the original motion to dismiss. There was the motion to renew the motion to dismiss based on this documentary evidence, the term sheet. There was the preliminary injunction appeal and the motion to renew the preliminary injunction. All of those legal appeals, all of the arguments, everything was inseparably related. I don't know how anybody could say that you could unpack that and contend that the discovery around those issues or the appeals wouldn't be covered under the undertaking. And with respect to the interest, I articulated what our position is on Flatbush. The only two other issues.
Counsel, what about the forbearance agreement, though? Would you concede that maybe if you get lost interest, it would only be from February 28th through the date of the forbearance agreement, which is April something?
So we wouldn't concede that, because the forbearance agreement merely has the borrower acknowledging that there's a default, that the debt is owed, and that the interest is going to continue to accrue. But the amount of interest that accrued from the February 28th issuance of the injunction to the April 9th execution of the forbearance agreement is over $25 million. It was accruing interest at $5 million a week.
Okay, that's a big chunk of change. Thank you, counsel. Thank you both. Hofstra v. United Educators. Please.
Good afternoon. May it please the court. Michael Levine, Hunton Andrews Kurth on behalf of plaintiff appellants Hofstra University and St. John's University. We're here today on cross appeals. There are two issues before the court. First issue is...
Let's start with paragraph 15Q and costs.
And the definition of funds.
I know you think the term is ambiguous.
So it is ambiguous, and it's ambiguous to the extent the court cannot reach a reasonable construction of that term. The problem that we're facing is that the Supreme Court jumped right in, and this is revealed on page 10 of the joint record in the Supreme Court's decision. Justice Frank says the first issue is interpreting the word funds in the exclusion. And that is not how the New York Court of Appeals requires that insurance contracts be interpreted. We start with the grant of coverage. We start with definitions to understand the scope of coverage, the context in which the policy was written, and then, if the exclusions are asserted, determine whether or not an exclusion applies unequivocally, without question, to the facts in the case. And that's not what happened here. The court started at the back. It looked at the exclusion 15Q, and specifically the term funds in a vacuum, without proper context for what this policy affords. This is critically
In the underlying
important.
action, what is it that the plaintiffs seek to recover from Hofstra and St. John's?
So they seek a number of things, but generally these actions are breach of contract actions for the alleged failure to provide on-campus education during COVID. When they went remote, plaintiffs...
They seek the return of tuition?
They seek to return what they paid for an on-campus experience, and that would be tuition and fees. That's what students pay. It's the only thing they pay, right? These policies specifically cover breaches of contract.
Other things too. Isn't there the potential in that case that their degrees have been diminished in value because of the lack of in-person learning, and they should be entitled to return of funds because of that?
Well, they're entitled to breach of contract damages, which in New York is the benefit of the bargain that's lost. That is what the New York Court of Appeals has said for decades. The measure of damages for breach of contract is the benefit of the bargain lost. So again, come back to what the policy
Maybe
covers.
that's what the policy is covering, but it's not covering the return of tuition.
My point is, we don't start there. Start with what it does cover. And what it does cover expressly is breaches of contract for educational services. It is an exception to an exclusion. It is in black and white in the policy. This is covered. So if it is, what are the damages that a plaintiff can claim for that breach of contract of educational services? There's only one. Under New York law, New York Court of Appeals said again and again, the measure of damages is the loss of the benefit bargained for. Here, the money paid for an on-campus educational experience. Those are the damages that are being sought. Now, you can call them whatever you want, but what we can't call them are funds in the context of 15Q. And there are a number of reasons.
Why can't they be called funds?
Because funds as used in the policy pertain to other amounts. They pertain to government grants, government assistance.
You've read that into, right.
No, if we look at the text of 15Q.
It says funds or gifts brought on by or on behalf of a government agency. So what weight do we give that or?
Exactly. So we have to read the provision as a whole, the policy as a whole, but certainly this provision. And when we do, under the settled rules of contract interpretation in New York, among others, we have the doctrine of justus generis, which says general words that follow specific terms are read in context and given the same meaning. Additional doctrine of nosi associs, which essentially means words as they're associated with. Again,
Don't we have
the
to
New York
give
Court of
the
Appeals-
words their plain meaning?
We give our words our plain meaning if we can, but that plain meaning isn't in a vacuum.
You said if we can't?
If you can. If you can.
Right.
Right, but that plain meaning has to be within context.
So
It's
you're
not in
saying
a
the
vacuum.
context is really any demand for return of funds or gifts being read together?
If United Educators' position were
And
correct, it
qualified
would
by
simply
brought
be a
by.
period after gifts. It would be return of funds or gift, period. We wouldn't have any of the additional language to talk about government grants, et cetera, et cetera. That's the context that was ignored by the Supreme Court. It cannot be ignored under the settled rules of interpretation in New York.
Thank you, counsel.
Thank you.
The questions, good afternoon, Your Honor. It's Ron Schiller for United Educators. United Educators also, just to be clear, is a risk retention group that's essentially owned by universities and schools around the country. It's owned by its members. These policies were drafted for its members. And the language of 15Q says this policy does not apply to, and we being United Educators, will not be liable for loss relating to or arising out of Q, any demand for the return of funds or gifts brought by or on behalf of a government agency or other entity or person. Now, they're trying to read out when the universities say that you should look at it as a segregated fund, the plain meaning of what I just read to you. We cited in our briefs, I won't repeat it, both case law and dictionary definitions. The first definition of funds is money. Gifts doesn't have to be money.
But if we were to, I think what his point is that we read that whole thing, return of funds or gifts brought on behalf of the government. Maybe wouldn't, if we were to read it separately, should there be a comma after funds? Funds, comma, or gifts, blah, 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 comma?
No, because it's funds or gifts brought by on behalf of a government agency or other entity or person. Any one of those things, funds or gifts, can be sought to be returned by a government agency, entity, or person. Obviously, students are persons.
And here we're dealing with persons.
Here we're only dealing with
That's
persons.
where you say the exclusion protects you.
Exactly, Your Honor. And
Students who have sued you in the underlying action are
yes.
persons.
And you asked a question, Your Honor, about going to what does the policy cover? Does it reach the diminution of the value of the degree? We have cases, United Educators, and we cited them on our brief. One of them happens to be called John Doe versus Hofstra, and it's in the Eastern District of New York, 2024 decision. It's a public decision, which, by the way, United Educators is involved in and aware of. And in that case, to be clear, they are not suing for return of funds. They are suing for exactly the sort of things that Your Honor was asking about. They are suing for things like the diminution of the value of the degree, the diminution of their earning capacity because they didn't get, in that case from their claiming Hofstra, what they were owed. In this case, there
Which
were...
is pertinent to the question of whether this is an illusory policy and whether what the obligation about a defense might be.
Yeah, and and our position is that because, for example, in the John Doe versus Hofstra case, they're not seeking return of funds. They're not seeking return of tuition or fees. They are instead seeking these other damages, and United Educators, therefore, policy is triggered and this exclusion doesn't apply. That proves our point. And we cited many other cases in our briefing, that these policies provide real value. They cover, for example, things like discrimination cases.
Counsel, let's pivot for a minute, though, because that also implies or implicates your duty to defend, doesn't it? And that's the other part, that's your appeal. You say
we cross-appealed. I don't think Your Honors need to necessarily get there, but because Justice Franks did refer to it as a duty to defend in keeping one little piece alive, and Your Honor's right, that's our cross-appeal with regard to the prayer for relief at the end, that there might be a duty to defend, these policies don't have a duty to defend. And as Your Honors are aware, we spell that out in our briefing. And what the universities contend is that we conceded they do. No, we didn't. We said we would win even if there were a duty to defend. But under both of these policies, Hofstra and St. John's have the right to and do control their own defense. And that makes a difference under New York law.
At the moment, is there a lawsuit pending against Hofstra, or was that one dismissed?
Dismissed. Good question, Your Honor. It was
Well, they still, I'm sure, incurred costs in it at some point, so you may.
Well, that's
if there's
right.
a
And
duty to
Hofstra
defend,
has
it
a
would still apply.
$250,000 self-insured retention, and St. John's has a $100,000 self-insured retention. But because they're not duties to defend, even if there were coverage, you'd have to allocate. Even as to defense, it's not like a duty to defend personal injury policy that provides that if you have to cover one count, you cover them all. This one includes in the definition of loss damages and defense. So even if something were covered, you would have to go and allocate even the defense dollars you're reimbursing. But it's not, Your Honor, a duty to defend policy. As we set forth in our briefs, both policies, and they're slightly different in their language. They
provide for reimbursement of defense costs.
Correct, Your Honor. But that's a meaningful difference. It means we don't control defense, and we include the definition, we include defense costs in what it is that you have to allocate. And I'll cover on my rebuttal in more detail. But the other point we made, Your Honor, is these students did not sue for anything other than the return of tuition and funds. And that's what we talked about in Q, and that's also what we talked about in the carve-out from the definition of damages. I'll get into that more in my rebuttal.
Your Honors, a couple of points. First off, the distinction between a duty to defend and duty to reimburse policy is a distinction without a material difference.
I thought you were going to say that.
Absolutely, and United Educators conceded the point 100%, page 589 of the joint record. They say the duty arises where the allegations of the underlying complaint state a cause of action that gives rise to a reasonable possibility of recovery under the policy. That's their argument, citing Fieldstrom. It's important to remember that there are other damages that are at issue here. It was not just the return of funds and fees, tuition and fees. And Justice Franks did pick this up. There were broad prayers for relief and other categories of damages sought. Now, the fact, Your Honors, that the Hofstra case has been dismissed with finality seals the fate of that case. There can be no determination of fees or tuition being sought. There were no findings made. There can be no allocation for that same reason. So Hofstra 100% is entitled to its defense costs in excess of its retention. Right now, the St. John's case is on appeal, and it's unclear. I believe a motion to stay was filed. It has not yet been responded to. It's unclear what will happen in that case, but it very well may go the same direction, in which case, again, there can be no findings and there will be no allocation. United Educators will be responsible for 100% of the defense costs in excess of the retention. Again, in interpreting 15Q, it is critically important, and again, not controversial under New York law or that of any state, that the policy is read as a whole, that exclusions are interpreted narrowly, regardless of who drafted them. That is the rule in New York, and that the Supreme Court in this case dove in headfirst and said the first issue is, how do we interpret funds in this exclusion? Absolutely wrong. You must start with context, which is the coverage grant, the definition of damages in this case, which includes money compensation for breach of educational services contracts. That's exactly what these lawsuits were about.
Thank you, Counsel.
The universities haven't pointed to a single case that says that the definition of funds or that the carve-out from the definition of damages is ambiguous. They argue to you, you have to holistically look at the whole policy, but this is a contract dispute. And when you look at the contract, you're entitled to apply common English usage as well as case law to determine what words mean. There's no distinction.
Why doesn't that same principle apply to the language that talks about the defense cost and the duty to defend?
I'm sorry.
Why doesn't that same principle look to the language applied to whether or not you have a duty to defend? I mean, I understand there's separate policies, but it's the same theory.
I'm sorry, I'm not following Your Honor, but our point is this is not a duty to defend, and therefore the issue is actual coverage, and the fact that defense is included within the definition of loss. In other words, it's not, for a typical duty to defend policy, defense is not included in the definition of damages or loss. That's why the policies provide defense on top of limits, which is not the case here. But the other thing, Your Honors, is look at what Mr. Gallagher and Mr. Shiv Patel, again suing St. John's, and what the two students, Stellato and Migliori, suing Hofstra, actually sued for. First of all, it's a purported class, and they say, but it wasn't yet certified. But the reality is that they pled it as a purported class, first in pursuant to Federal Rule 23, and then pursuant to the CPLR in state court, and that meant they had to prove commonality and typicality. That means they weren't alleging. There is nothing in the complaint alleging diminution of the value of their degree or anything else that would support that the prayer for relief might reach a different sort of claim than the return of tuition or fees. What they said, point blank, is we want our tuition and fees back because you took tuition and fees to give us a certain kind of educational experience which we didn't get. The only other thing that I wanted, and I know I'm out of time.
30 seconds, counsel.
Thank you. That I wanted to cover is the disgorgement restitution issue, Your Honor. This is one that we cross-appealed on only because it's an independent ground for relief for us. Under New York law, if the universities have money to which they're not entitled to get insurance for it. Justice Frank extended that, and we think wrongly, to say that only applies if it was initially wrongly obtained. And since the tuition presumably was obtained before the pandemic started, therefore, disgorgement restitution law doesn't apply. That's not the law. That's not vigilant. And the whole purpose behind saying that disgorgement and restitution are uninsurable is not just to keep a thief who intentionally steals from benefiting from holding on to the money, but to keep organizations, people, or in this case, universities, that got money that they didn't earn from holding on to it. And we cite the law on that.
Thanks, counsel.
Okay, thank you.
Thank you very much. I am recused on the next case, Kedskavich v. Victor. Justice Friedman will do the honors.
Good afternoon, Your Honors. This is Joseph Field of Littler Mendelsohn for the defendant appellant Manhattan Place Condominium, which I'll refer to as MPC. This appeal raises the meaning of the term agent under the City Human Rights Law 8-10713, which prohibits an employer or agent of the employer to discriminate against a person. Justice Hagler got it right the first time when he granted MPC's motion for summary judgment in March of 2024. He then reinstated that one claim under the human rights law for sexual harassment on re-argument. And we're asking this court to modify that decision by dismissing that single claim. So there are two issues here. The first one is, as this court found last August in the Victor versus Kostevitz case, a person has to be aggrieved under the human rights law before there can be any liability. And that's under 8-502. What this court found in that case was that a counterclaim for retaliation brought by Tyler Erdman against Mr. Victor and also against MPC, which was brought in as a defendant, could not proceed because Mr. Erdman did not have a relationship which could be fairly characterized as one of employment. So in order for Ms. Kostevitz here to have a claim, she must have essentially standing to pursue such claim. So under the logic of the Victor versus Kostevitz case, and I believe that Judge Weber stated at the oral argument in April of last year that Mr. Erdman was incorrect when he said any person is covered by the statute. It has to be someone who has some sort of employment relationship. So what Justice Hagler did find here was that Ms. Kostevitz was neither an employee nor an independent contractor of MPC.
Were there allegations that she maybe took notes or minutes at meetings? Was there any significance to that?
Yeah, the significance is when you look at all this is in the record as to how they met. So first of all, the plaintiff met Mr. Victor when she was acting as a massage therapist. So it was not a normal type employment relationship under any stretch of the imagination. But her testimony is that she functioned as a personal assistant to Mr. Victor.
So any of her interaction with MPC was based on her being an assistant for Victor?
That's correct. And she said, and again...
Counsel, what about the argument that Victor was acting as an agent for MPC? Is there any weight to that argument?
No. Okay, so if you look at 8502 and 810713, the agent has to be acting within the scope of the agency. And the scope of the agency requires that the person be acting on behalf of the entity in which they represent. Now, the word agent, there's no definition. There's, I believe 59 definitions under the city human rights law. Unfortunately, agent is not one of them. So we have to look to common law principles to determine what do you mean by an agent. And we cited a case in our brief on the scope of agency where someone was working, I think, at a bank, and the court found that them defrauding a potential or an existing client was not within their scope of their agency. So Mr. Victor, whatever he was doing, was not acting as an agent of MPC. And when Ms.
I think a part of what they're alleging is the fact that he owned so many units in the building and that he was the board president, and so he made a lot of decisions for MPC.
Okay. So acting as the president doesn't mean that you're tagged with every type of liability that exists. And I think that's an important point, Your Honor, is that, let me just say one thing, that he owns 7 units in the condominium, including where Ms. Kacevic worked. Thank you.
Good afternoon. John Brennan for the plaintiff respondent. We've reached a point here where the president, the #1 officer, the moving factor in virtually every decision that this condominium...
Does plaintiff have to be an employee of the condo for you to prevail?
Excuse me?
Does plaintiff have to be an employee of the condominium for you to
I would submit that no, he doesn't, that he can be an agent, and he is an agent. Now, if you want to go down the MPC's road here, what you're going to end up with is nobody's ever going to be liable under this statute. You can't find somebody's an agent. You can't find they're an employee or employer, because that section will be effectively written out of the statute, because nobody can meet it, because nobody would include discrimination, sexual harassment, whatever form it takes, within the scope of somebody's agent.
Counsel, in terms of that argument that you're making, in order for you to show agency, you have to show that Mr. Victor was acting on behalf of MPC and that he made personnel decisions to bind MPC. Like, those quintessential factors that create an agent relationship don't exist here.
Yes, they do, Your Honor. For instance, in the record, I believe it's in the teens, late teens. They discussed the hiring of Mr. Kirchner. He hired Mr. Kirchner. He's the one who hired the plaintiff here. He's the one who decided who...
He hired the plaintiff to work for him personally, but not...
His assistant.
Correct,
not as an employee of MPC. She did nothing for the MPC.
No, she went to meetings, she coordinated things.
As his assistant to assist him.
Was it to assist him, or was it to assist the building? She was doing work, 50% of her work was spent on building matters, going down, inspecting things, looking at samples of materials they were going to use, writing to outside contractors.
In Victor's role as president.
Excuse me?
Victor's role as president.
Well, she did that work. She actually did the work. And that's incidentally one thing is not disputed here. She did this work. She spent that time. That is undisputed on this record. What
Did the condominium pay her?
the condominium paid Mr. Victor, yes. They compensated him for.
Did they pay the plaintiff?
They did not pay the plaintiff directly, no.
And her work wasn't just with MPC. She woke him up. She packed his personal belongings. She picked up and dropped off dry cleaning. She handled food and package deliveries.
You could
And she took some notes for MPC in his role as president of the board.
And you could probably add another page and a half of things she did for Victor and MPC. Victor moved her into MPC. That was part of his agency as he saw it. That is part of his agency as he practiced it.
Did she ever receive any direction from MPC's board?
She did not receive any direction from other board members of MPC. She didn't need to. He is the board member. He's the one who dominated everything at this condominium.
Thank you.
Thank you.
Your Honor, just briefly, I think the words of the witnesses say a lot here. So I just want to point your attention to Victor's testimony, which said MPC really has no business being in this case in the first place. The lawsuit against MPC was a ridiculous sham. That's at pages 1111, 1112. And the plaintiff herself said, quote, I know Adam Victor was the employer and I would work per his direction. So in other words, she continued to work as his personal assistant. She could have been a scrivener, she could have attended meetings, but he was the one that hired her, he was the one that paid for her. There's no dispute that NPC never sent her a check. In fact, she alleges at one point, I think during the oral argument, I think the court thought that maybe she actually received a check, but in terms of her actual testimony, which I submitted a letter to the
Counsel,
court.
there is no dispute that MPC did not employ her,
Correct.
correct?
Yes. Thank you, Your Honor.
Thank you. Thank you both. Doan versus City of New York.
Doom v. City of New York.
Good afternoon. May it please the court. My name is John Scola on behalf of Appellant Jose Dume. I'll be pretty brief here. This is a 3211 motion for race discrimination, retaliation, and 75B retaliation. The court erred in applying the wrong standard. As we all know here, it's a notice pleading standard. The court recently in Enriquez stated that you don't even have to set forth the four elements of a claim as long as you put the defendants on proper notice. I'll just go briefly through my claims here. Plaintiff identifies specific comparators or undercover detectives who were not Hispanic, who he identified as received greater benefits, including more overtime and other employment benefits. There's several comments. There was a comment made about his Dominican national origin. Thereafter, there was only, they were placed on, there was punishment posts that were only given to Dominican officers. They also only kicked out Dominican officers from the gym. Now, for the retaliation claim, he objected to that initial Dominican comments.
So the gym incident, that was one incident. And I don't know, doesn't the complaint say they allowed a Puerto Rican undercover to remain in the gym? I'm not saying, obviously.
It's a Dominican national origin case. He specifically made questions about Dominicans.
Aren't these isolated incidents, though?
No, they're not, Your Honor. If you take them as a whole, the comparators that earn different overtime in and of itself would defeat a motion to dismiss. Under Serrano, comparators that were given different benefits based on a protected characteristic would also trigger a hostile work environment claim. I think if you look at
let's talk about the sequence of events that lead to the retaliation claim.
Sure.
I feel like that's a stronger claim for you. That's my opinion.
Thank you. Yeah, I like them all personally. But the retaliation is there's two parts of the retaliation. The first one is they're committing fraud on the overtime. So there's mandated overtime for arrest, 3 for a felony, 1 for a misdemeanor. My client objected to that. They retaliated against him for that one. Then after that, he objected to the comment about what is the Dominican doing in Ukraine. That in and of itself is a protected activity to a supervisor. Then flash forward immediately thereafter in retaliation for those complaints.
How is that comment about Ukraine tied to anything else that happened in the case?
He said, what's the Dominican doing in Ukraine? That's after the disparate treatment based on race and national origin. So it sheds.
But what's
What
disparaging
was the
about that?
disparate treatment?
Oh, no. So the comment sheds light on the motives behind the hostile work environment.
And what do you tie that comment to? I mean, it's whatever you make of the comment, and obviously the plaintiff didn't like it, but it's not tied to anything else.
Well, he was calling, so at the time, he was calling him after he found out that my client disclosed.
He also says he's worried about him.
Well, okay, so the court must have taken everything to say his plaintiff as true. We're saying that comment was derogatory and led to, it sheds some light on the true motive here, which is discrimination. We have comparators that were treated differently who were non-Hispanic and not Dominican. The
Counsel, after he complains about the national origin comment, what happens regarding the evaluations?
They try to break into his house to take an evaluation and then lower his score. He actually
Because the first evaluation was positive.
That's correct, Your Honor, and it was the stater here.
That's not tied to the comment about Ukraine. It's tied to the suspicion that isn't that tied to the fact that they think that he's reported the overtime abuse?
So what their motives are, we don't know.
That's what generates the.
It could be part. It's both. It's both. So he objects to the Dominican comments, and then makes right after that they try to go to his house and take the evaluation. Thereafter,
Yeah, but my colleague is correct. What is the Dominican doing in Ukraine had nothing to do with them trying to replace the evaluation. I mean, I don't understand what's disparaging about that comment.
Okay, so I guess there's different things here. The disparagement of the comment is not. It sheds light on the overall totality of the case, where we show specific comparators who were also Hispanic that were treated adversely, and then we also show people that were not Hispanic that were treated more favorably. He objects to the Dominican comment on the call. The purpose of the call was to revoke the leave permission because he complained about the EZU.
Doesn't the situation with the claim of a potential break-in relate to the fact that obviously some of his colleagues come to suspect him as being the sources of a report that there have been overtime abuses?
Right, so that's a 75B retaliation claim.
Okay, but it's not tied to the comment about Ukraine.
The raid happened within hours of him objecting to the comment about the Dominican national origin. He believed that was a complaint of discrimination. Flash forward, set that aside for a second. A week after he returns, he makes an EEO complaint for race discrimination. Thereafter, they tried to psych him, remove his gun, and send him to psych services. That in and of itself is retaliation for the EEO. The 75B retaliation is something different. That's for when he complained about the EZU. That's when he's on the phone. That's when they do the AWOL. They strip him of his overtime from 40 hours to 0, and then a whole host of things ensue. The court must take what we say at the pleading stage as true.
We know that, counsel. You have time in rebuttal.
Thank you, Your Honor.
Thank you.
Good afternoon. May it please the court, Mackenzie Filler for the city. This court should affirm because, for multiple reasons. First, the plaintiff does not have a 75B claim because he failed to file a grievance. The statute itself says you have to exhaust your remedies, you have to file a grievance first before you can pursue a 75B claim in court. And he admittedly
Put the microphone a little closer to you. Thank you.
Sorry, he admittedly did not file a grievance. And even if you put that aside, the complaint does not state a claim for 75B.
Discuss retaliation under the HRL?
Okay, under the HRL. So he alleges that in September 2022, he complained about discrimination, and that is for sure a protected activity. But he doesn't allege that anything that happened after that, he doesn't allege anything that would raise an inference that anything that happened after that was as a result of that complaint. He doesn't allege that anyone even knew about it.
Isn't there some evidence or at least an allegation that Wilson made a comment about that plaintiff was supposed to get charges and specifications?
He was charged with being AWOL, yes. But
on a vacation that was taken with leave.
I mean, I can tell you what happened with the charges and specifications is not on the record.
So, but But as a matter of the liberal pleading standards which apply here, doesn't that suffice to make out the retaliation claim?
No, I don't think he actually even alleges that it happened after he made the complaint. And he doesn't allege that anyone knew about the complaint. He doesn't allege timing of any of these things. He doesn't, those are the things that you have to allege to show some sort of inference that someone was retaliated against, that they knew about your complaint and that they did it, you know, because of that, and that timing raises an inference of that. But he doesn't, this complaint contains no such allegations. Half of it's written in the passive voice. So it's like overtime was stripped. And it doesn't say by who, when, did they know? I think that what my colleague here wants you to think is, you know, there's a whole lot of allegations here, so there must be something, and you'll just throw up your hands in reverse and send it back. But if you read it very carefully, there's no allegations that suggest racial discrimination, national origin discrimination, or retaliation.
Thank you, Councilman.
Thank you.
I mean, I think the complaint pretty clearly pleads all of these claims here. First and foremost, the failure to exhaust administrative remedies. The case that's cited there is the MTA case, the Gregory, I believe it's pronounced. In that one, the MTA had a collective bargaining agreement that explicitly stated that you must file a grievance with the union before you can bring a case here. There's no claim, my client was a detective, now he's a sergeant. There's nothing in the DEA contract or the SBA contract that says that you have to go through a union grievance before you can sue someone for a 75B claim. That if it was, it would be cited. There's nothing there. They're trying to extend this to the Gregory case in order to bar all 75B claims, essentially. The union doesn't have any power to litigate a 75B claim. That's the whole purpose of the statute. That's why we're here. Now, it's pled with particularity that within the proximity of the complaint, when he returns, he had his overtime stripped. And it was in retaliation for his complaints. Again, this is notice pleadings. Plaintiff put the defendants on notice of our claims. Now, it seems like there's some issues over the hostile work environment case. We have it pled particularly with specificity that my client was denied benefits of employment along with other Hispanics that non-Hispanics were not. We have specific comparators in there that we allege are similarly situated that were denied benefits on the basis of race. Again, with notice pleadings, the defendants are on notice. Thank you, guys.
Thank you, Councilman. Thank you both.
We'll stand when you guys leave, too. We'll stand when